All right. I guess I will take up the barbell. I will pass the chairmanship to Mr. Wagner. All right, we are on item 9, AB2878, a judiciary bill dealing with the State Bar. Mr. Chairman, when you're ready, you may proceed.
Thank you, Mr. Chair and members. This is the annual State Bar dues bill that comes before us. It is generated out of the Senate one year, the Assembly the next. This is our year to do this. And it keeps the bar fees of $390 the same as they have been for the last 3 years. This is also the legislature's opportunity to fulfill its oversight role of the State Bar, and that's what this bill does. Now, we have several items that we are still waiting for. The audit that was called for in the last year's bar bill. We are also waiting for the governance task force for the bar to complete its work, as well as the spending plan and the workforce plan. So as this bill moves forward, we will be seeing some amendments in this House and also as it moves to the Senate.
May I interrupt you for a moment? It's my understanding Ms. Gonzalez wanted to be here for this bill, so if we could have the sergeants contact her office and let her know she's on her way. Very good. Make sure she had that opportunity. Thank you.
Thank you. Thank you. So what it doesn't do, what this bill does not do yet, is address those issues that will be coming to us through the audit, through the governance task force, spending plan, workforce plan, and others. Members of this committee have raised issues with the bar bill and with the organization of the bar. I think clearly what has been in the paper and what has been talked about quite a bit with the bar is in the middle of a lot of reform. I think it is incumbent on the legislature to be a significant part of that reform and ensure that the bar meets its obligations, public protection, of managing the lawyers in the state of California. I've been meeting with the chair of the Senate Judiciary Committee as well as the Chief Justice and executives from the bar in order to facilitate that conversation and make sure that as the bar bill moves forward, we have vetted all of the issues we need to vet, that we put the amendments in and do our job of governance and oversight with respect to the State Bar. We do have some witnesses in support. Elizabeth Parker is with me, who is the State Bar Executive Director, and I know that there are lots of perspectives on this. I was hoping by the time we presented this we would have a full committee, because I know committee members that I've been in conversation with have questions and concerns about the State Bar moving forward. This is our opportunity, and with that I'll move to our witnesses. And I would also like to invite committee members to make sure that they stay engaged with this conversation, because as the bill moves forward, it will be amended. My promise to the Chief Justice is to keep her well informed. Obviously, we're working very closely with the Senate Judiciary Committee on this, and I want to make sure that all of the members of Assembly Judiciary Committee are as well informed as possible as this bar moves, because we are the spokespeople for this bill with respect to our colleagues, and when it goes through the appropriations process to the Assembly floor over to the Senate, we're going to be the ones held accountable to what's in the bill. So with that, I ask for your aye vote at this point and look for our witnesses. And Ms. Gonzalez.
First witness in support. Welcome.
Yes. Well, thank you very much, Chairman Stone and members of the committee. Good morning. I am Elizabeth Parker, and I have with me the two other members of our new leadership team, Leah Wilson, and behind me, General Counsel Vanessa Holton. I want to begin by complimenting the staff who prepared a really wonderful analysis, and I think probably it is so thorough that I don't need to say a great deal more, but a couple of personal comments, if I might. The new team, pardon me, I seem to have caught whatever it is that's going around this room. The new team,
it's an old building.
Okay, is now just entering its 7th month, and so we are brand new and learning and working hard to accomplish, frankly, a very important set of tasks that you set upon us last year and that are very valuable, and I'm sure you're as familiar with them, but I'll just simply name them quickly: workforce planning, classification and compensation review, zero-based budgeting. Importantly, we've already managed to reduce our budget this year by 6.2%, so we do hear you. And we're also addressing a long overdue need for a new case management system, as well as redesigning our website. So your oversight process and that of the Supreme Court, we think, is really working effectively. I should add, however, that as a brand new team, we do have a great deal of learning to do. And I might just explain as to how we arrived, all three of us, simultaneously in September, October. Our Board of Trustees, as you may have observed, is not always unanimous on all points. But on one point, I think they did agree, and that was that the bar needed a new direction. It needed an approach that would be transparent, accountable, and would achieve excellence through establishing the trust we need with your committee and the Supreme Court. And to that end, they chose to reach out to those who, while they'd had management experience, had never had any involvement with the bar in a management capacity. And I think what they were signaling for you is change, transformative change, and indeed that is what we are about. We have committed ourselves to own, albeit we may not have originated many of the problems you've described. So we do have legacy problems. We're aware of them. We didn't make them, but it's our job now to correct them, and that is our pledge to you. We have another pledge which I want personally to underscore, as I have to many of you individually, and that is, as a new team, rushing fast, we may make mistakes. Indeed, I think several of you will be able in questioning to point to some of those mistakes. But when we do, we also pledge that we will come forward and be honest and complete in correcting those mistakes. And I think you really would have to agree that that is what you would expect of any servant of the public, particularly one engaged in public protection. Now, I know my time is limited, and so let me end with just a thought as to the context in which many changes are being suggested this year. These are, what shall we say, interesting times to be the executive director of the State Bar. We have a vitally important, I believe, public protection mission, and indeed it is why I chose to leave retirement and join the bar as its executive director. But when we think of that public protection mission, I would encourage that we think not just about responding to those who violate rules, but also thinking proactively as to the legal system we want. You mentioned, importantly, the support that the bar historically has given for legal services. But if you consider that the problem is much broader than that, with 85% of our population not represented currently, and indeed many of our diverse population not feeling inclusion, I think you see that we have a proactive public protection mission that has to combine with our responsive public protection mission. And so with that, I'll say that we look forward to working with this committee and with the Supreme Court in achieving an even better bar, state bar organization.
Thank you, Ms. Parker. Additional witnesses in support?
All right, so this is a little unorthodox.
All right, this is a little unorthodox.
We find
Nevertheless,
no other way to do it.
the chairman and I have discussed it, and out of deference and consideration to a colleague, you may have a couple of minutes and
Thank you.
proceed.
And thank you, Chair, for allowing me, and Vice Chair, to allow me to join you today at the committee hearing for AB 2878. I'm a proud member of the California State Bar, and every year I pay my dues, happily. But as an attorney, and more importantly, as a legislator, I assume the bar is doing its job. Pursuant to Business and Professions Code Section 6001.1, protection of the public shall be the highest priority of the State Bar and the Board of Trustees in exercising their licensing, regulatory, and disciplinary functions. Whenever the protection of public is inconsistent with other interests sought to be promoted, the protection of the public should be paramount. It seems, however, that protecting the public has not been the highest priority of the bar. In particular, the bar has completely neglected to address nearly 300 complaints dealing with the unauthorized practice of law. According to an article published in the Daily Journal, these cases were simply placed in a drawer that said "read drawer." Furthermore, the annual discipline report to the legislature lacked information data regarding the unauthorized practice of law claims. This is especially disconcerting given the bipartisan passage of two bills through the legislature and signed by the governor, AB 1159, which was in fact sponsored by the bar, and AB 60, directing the State Bar to help protect immigrants from the unauthorized practice of law, as well as fraudulent attorneys. Under the Chief Trial Counsel's leadership, we've seen inaction and buildup of the UPL cases. The inaction of investigating UPL cases, of course, deterred new claims from being made by people since they don't expect to see results. We've had multiple hearings in this building about the need to allow the bar, or actually ask the bar to handle these, because so often immigrants have no place else to go. They often will not alert a DA or city attorney for fear of the consequences of doing so. So the bar was, in fact, they stated and continue to state that they were the appropriate place for immigrants in particular who were being defrauded by notarios and others who had nowhere else to go to the bar. I think it is more than disconcerting that all of these complaints, as far as we know, were placed in a drawer. And as much as we're talking about transparency and a new governance, we were never told about this. In fact, it was a whistleblower who alerted the Daily Journal to this problem. I think it's a responsibility of the bar and our responsibility as a legislature to ask these questions, and I know of no other time to do it except to ask when the bar comes forward and asks for their dues bill. Again, I pay dues. I appreciate that. I know that this is an important bill to get through, but I also think it's an important piece of our role to ask and question what the plan is in order that we actually see the bar protecting all Californians, especially those directed by this legislature to protect the most. Thank you.
All right. I am going to ask Ms. Parker or whomever to respond when the time comes. We're kind of a little out of order here, and at this point, let me ask, are there any other witnesses in support? All right. Witnesses in opposition? Witnesses sort of in the middle? Yeah, I mean, you're welcome. Mr. Majors, welcome. Former member, welcome back.
Thank you, Mr. Chair and members. My name is Dennis Mangers, and as many of you know, I had the great honor to serve in the State Assembly in the 70s while most of you were children. At the end of my professional career, the Senate asked me if I would accept an appointment as a public, non-attorney member of the State Bar's then Board of Governors. And I agreed, and I'm now in my second term. When I entered my first term, under the recommendation by the Senate that I analyze the governance of the State Bar, I was assigned to the Task Force on Governance in the Public Interest, during which I came to the conclusion that the major problem at the bar, and the only real way to solve the litany of issues that you see in your very fine analysis, was ultimately to separate the regulatory and trade association functions that are currently unified in the California State Bar. At the time, the legislature did not have the stomach, it seemed, at the time to take that issue on, and I was advised to make other recommendations, which I did, two-thirds of which ended up in a bill called SB 163, which reduced the number of members of the Board of Governors, and it reduced the number of electeds, if you can still believe that attorneys elect one another to the regulatory body, but it was tinkering around the edges. So, Mr. Chair, now I'm a member of the yet second task force on the governance in the public interest, and I call your attention to page 14 of your very detailed analysis, because the crux of what I'm recommending to you today is that I support the fee bill, but only if ultimately amended, to finally deal with the major critical issue before us, and that is this body has become distracted from its regulatory responsibilities because of its fascination with its trade association functions, and that has to end. So what you've read the analysis. I've had the opportunity to talk to most of you, so I will not take a lot more time except to say what my colleagues and I, who are taking this position, are recommending is that Mr. Stone, the very capable chair of this committee, and Senator Hannah-Beth Jackson, his Senate counterpart, collaborate with the Chief Justice. And together, they resolve that what this legislature will do on the Senate side is adopt amendments that will direct the bar to come back to this honorable body within a year with a plan for how it can deunify itself into two separate bodies, as most of the other major states in California have done. And a year hence, the legislature will then enact enabling legislation that by January of 2019 will find the California State Bar finally decoupled with regard to its trade association and regulatory functions. If the judges can do it, as they did years ago, if the doctors can do it, as they did years, as the doctors asked the legislature to help them do, then surely there is no justification for attorneys being the only remaining profession in California that is still allowed to regulate itself with self-elected lawyers who often believe that they are representing constituencies of lawyers in their respective districts more so than they are the public protection. So I ask you, as believe me, a totally objective, what is in it for me, a totally objective, non-attorney public member sent by the legislature to make this analysis, it's taken me nearly 5.5 years to come to this irrefutable conclusion that this is what we must do. While it won't happen, I'm told, in today's hearing, I believe that this chair and Senator Jackson, with the chief, could come to an understanding that would ultimately lead to legislation in this regard. So I hope this committee will send strong messages to your Senate counterparts that you have the feeling that the time has come, the winds of change are upon us, and that it's time to separate these two functions at last. Thank you, Mr. Chair.
Thank you. Additional witnesses in opposition or sort of opposition? Go ahead.
Thank you. My name is Heather Rosing. I am an attorney from San Diego. I just finished a 4-year term on the Board of Trustees. I'm attending today with Mr. Mangers. I was a 2-time officer of the State Bar of California, and I am in support of substantial changes to the governance structure. Mr. Mangers articulated our position, which is that the chair work with the Senate side and the Chief Justice to adopt the amendments we propose, essentially to deunify or decouple the bar. I just wanted to give you a little bit of our reasoning, and I will be brief. The Board of Directors of the State Bar of California is a well-intentioned and very good group of people. We have an immensely talented staff that I cannot speak highly enough of. But this is an immensely complicated organization. With so many moving parts, it took me a year, my whole first year on the board, to even understand it. And I can tell you with great certainty, because of all of the different moving parts in the organization, there is a distinct lack of focus on the core regulatory function, which is discipline. And that is, again, from my 4 years on the board, and Mr. Mangers and I have been very involved in the discipline system in particular. I can tell you what happens when there is a singular focus on a regulatory function, because we do have that in one component of the State Bar. The State Bar has a committee called the Committee of Bar Examiners, and it's different than the Board of Trustees, and all they do, they have no trade association functions, no professional association functions. All they do is regulate admissions. An amazing group of people. And you know, the best functioning part of the State Bar of California, by far, in my opinion, is admissions. So we've shown what we can do when we have a focus on the regulatory function. I can tell you, too, that the organization, in my opinion, has had some challenges with being, as Mr. Mangers has utilized in his phraseology, spasmodic. For example, we have been asked to do strategic planning by way of SB 163 in 2012. A strategic plan was proposed by the staff. It was entirely staff-driven. The board gave it almost no focus for many years. Then last year, we went through a very intense strategic planning process, and then that strategic planning process was completely abandoned subsequently. There has been little resemblance to anything that could be called strategic planning in the State Bar. I truly believe that if we were to take the regulatory functions pursuant to our proposal and have that board, that body, concentrate on the core functions of discipline, admissions, and the other regulatory aspects, and we allow the rest of it to go into a trade association or professional association environment, it would be good for everyone. It would serve the public. We would be able to best protect the public with our focus on the regulatory function. And as somebody who loves the profession of law and loves lawyers, I can tell you that the profession of law would be well served by a trade association that would not be burdened by the many constraints of a regulatory association. So we thank you very much for the time, and I appreciate the opportunity.
Thank you. We've had one witness in support, 3 against. So at this point, Mr. Howard, name, organization, and position, and we will move on.
I think that they're in support if amended.
Support if amended.
Right.
It sounded like an awful lot of opposition to me.
Thank you, Mr. Chairman.
Name entity and position, and we will move on. Thank you.
My name is Ed Howard, Center for Public Interest Law at the University of San Diego, in strong opposition to this bill.
Thank you.
Thank
Are
you.
there additional witnesses in opposition? Okay, I think we had a late arriving support.
Good morning. Thank you. I was trying to get in the door, so my apologies. You went so quickly on the support. My name is Gina Lara. I'm a practicing attorney in estate planning, trust, and probate law in Sacramento. I've been practicing 20 years. I'm also the vice chair of the Trust and Estates Executive Committee of the State Bar. I've been serving on that committee for over 6 years. I have another 4 years to go in my term. And I wanted to just speak on behalf of the Trust and Estates Executive Committee relative to this issue of deunification. That is, there are executive committees of the State Bar in various practice areas. For example, trust and estates, business law, labor law, family law. And these executive committees consist of dedicated, hardworking attorneys whose sole focus is to advance the state of the law on behalf of the public. To refer to us as trade associations associated with the bar, in my opinion, and I think the opinion of the members of TexCom, is grossly unfair and grossly understates the service that we provide to the public. We spend hours. I was the chair of the legislation committee that was part of TexCom. I chaired that. I served on it the entire time I've been on TexCom. We review, pardon me for rushing, every piece of legislation that is proposed through our committee. Every piece of legislation that is proposed. It took me over 2 hours each day to review your hard work that you put out each year. During the legislative season, to make sure that there was not a proposal that was in our domain or touched our domain that would not be to the advantage of the public. So to refer to the executive committees of the State Bar as trade associations, those are for lawyers serving lawyers. The ABA, in my opinion, American Bar Association, is for a lawyer serving lawyers. We don't want to become the ABA. We want to be part of the State Bar. We want to advance the public interests of the State Bar through our practice area. We consider ourselves subject matter experts. We are not trying to feather our nests. We're not trying to have martinis after our meetings on Saturdays. You know, when I have to get up at 4 o'clock in the morning and fly to LA. And then, you know, we're not trying to get the bar to pay for those things. What we're trying to do is advance the public interest. So we strongly, and I guess I should get to my point, oppose any form of deunification. And I feel today, I read with interest the analysis of this bill, and I feel like I've stepped into a firestorm. And I'm not saying the State Bar doesn't have problems. When I saw the loans and the lack of discipline for the unauthorized practice of law, I was just as appalled as the people who testified in opposition. But to punish the sections for this, when we try so hard to advance the public interest, I think is really inappropriate. And I came out today on behalf of TexCom to let you know that we are opposed to it. I understand, and I'll conclude now, that there's about, and I wish I was more prepared, 16 sections in the executive committee sections in the State Bar. Only one of them wants to deunify. The rest of us want to stay with the State Bar because we're proud to be part of the State Bar. When I say I'm part of TexCom, when I'm the vice chair, which is Trust and Estates Executive Committee of the State Bar, I say it with pride because I think we're doing good work. And so I would ask you to, I feel like it's not properly before you anyway, the deunification, because it's not in the bill, but when it's amended, I hope you'll at least remember my impassioned and slightly neurotic comments and you know, think about the deunification and what it will do to our group. We will no longer be advocating for the public. We'll be advocating for lawyers who practice estate planning, which I think is a huge disservice to the public.
Thank you.
So thank you.
Thank you very much. Additional witnesses, and I think we're just to name, affiliation, and position, please.
Vanessa Kirker-Wright, I'm the chair of the family law section of the bar. We join with TexCom's comments and hope that you'll continue to have us be as stakeholders
right,
as this bill moves along with regard to deunification. Thank you.
Thank you very much.
Donna Parkinson, former chair of the business law section and secretary to the California Lawyers Guild, a newly formed statewide organization. It's inaccurate to say that 15 out of 16 of the sections are against the disunification of the bar. There are about 5 or 6 that have taken a position, but for the most part, they're either not taking a position or business law section has taken a position in favor of disunification. We support the Mangers-Rossing restructure proposal.
Very good. Thank you very much. Additional witnesses, I guess, on any side of the subject. All right, let's bring it back to the committee. And I saw Mr. Mainshine first and then Mr. Chu.
Thank you very much, Mr. Chairman. I wasn't planning on speaking, but my friend and colleague, Ms. Gonzalez, has kind of inspired me to say a couple things. You know, I also pay dues to the State Bar, and read with interest the 2015 State Auditor's Report, which was scathing. I mean, it was really, pretty disturbing to read. I do appreciate that some steps have been made in the last year on this, but I think a lot more needs to be done. Ms. Gonzalez raised some pertinent points about this, and I think there's a number of others that were identified in that report that still need to be addressed. It's good that steps are being taken, but there's a lot more to do. I would, one of the comments I think that I heard was, this is some of the proposals are some sort of punishment. I guess I would, at least for me, what I'm interested in is having an agency that functions correctly. It's not, I don't think there's punishment on the correct functioning of an organization, not wasting money, serving the public, disciplining lawyers that don't practice law correctly. So I don't think it's about that in any way. I'm very interested. I haven't had a chance to evaluate this deunification proposal. I am interested in it because I think it raises some really good points. And so I want to learn more about that, and that might be something that I would be willing to support in the future. I'm glad we're not talking about a dues increase this year. So I think you are showing some awareness on that topic, so that's appreciated as well. And I'd like to hear more as we move forward in the next year. Do you have plans? Let me ask you this. Do you have plans on this deunification? What is the status of this proposal?
Well, this is part of our delayed 2014 Governance Task Force, Public Interest Governance in the Public Interest Task Force. Now, why it wasn't done in 2014, I cannot tell you, but we're busily doing it now. We framed the questions broadly because we wanted to create a big tent so that all questions could be thoughtfully looked at. We're rushing fast and hoping to have a report to the board for its consideration in July, and then that would come to the Supreme Court in this body and, of course, your counterpart in the Senate soon thereafter. I think the conversations by everyone's agreement have been robust, diverse as to viewpoint. If I might just take a moment and tell you what my personal perspective is. When I arrived, one of my first conversations was with Heather Rossing, and I said, do you think we should be talking about splitting this bar apart? It looks kind of complicated to me. In fact, I did a little diagram here so I could understand it. I thought if I were in a corporation, I'd say, let's just focus on our principal form of business and shed the rest. But from that position, I've come to realize, as I gather you have, that it's more complex than I earlier understood. And when I referenced some of the proactive things we need to do, if you look at the various functional areas, one question that arises is, where do you draw the line? So certainly some of the things we do to protect the public are responsive to bad actions, but others, which you've mandated as a legislature, look forward. So a number of these things, and of course the sections are complex as well. I think at the end of the day, the one thing I will say with some conviction, and I'm perhaps I'm choosing an unfortunate metaphor, but if you had a sick patient, you'd wait until the patient was healthy before operating. And I think our patient's still a little bit sick. We hope we can cure it. We hope we can take advantage of all of the good work the auditors and this committee have done, and that when we come back in about a year, we will have a robust, well-functioning organization, at which point it might be wise to think about what is the best way going forward. I'd add, too, that as you think about this, and frankly, my 7 months has not been enough to really grasp this profoundly, it is interesting to look at other states in the United States to see how they do their business, but also to look beyond our borders. Ironically, California is so large that it's almost in a class by itself, and so you almost have to look to other nations to see what kind of structures might or might not work. We're very much, I think, at the beginning of this. It is an important thing to be looking at. I think what we will be able to deliver to our board and to you will be questions, they may not all be thoroughly reviewed and considered. I doubt we'll have firm recommendations in such a short space of time. And so to that end, not wanting to make light of the important administrative and management work we have to do, I think our concern is that we get through that first order of business and then move towards what's an important second order. Should we or should we not continue with the current structure?
Well, I guess I might I think I agree with some of your comments. I would respectfully disagree that, you're rushing through this. This is a 2014 report, right, that we're talking about.
That's true.
So
but
it's not 2014
No,
anymore.
but it was not begun for reasons I don't know until I arrived in December.
I understand that. We're still talking about receiving something in
Sure,
2016.
you are. That's
I think that would be a mischaracterization. It would mischaracterize it to say that's rushing it. So we're now into 2016. Hopefully, we'll get it in July. Obviously, we'll wait and see what it is. You're right. California has way more attorneys than any other state, and looking to Connecticut or some of these other states is not going to be helpful. I'm not entirely sure what looking to other countries will do, but I'll reserve judgment on that. What I think is important is this is an organization that, Ms. Gonzalez pointed out, kind of a one niche area, but there's a whole lot of other areas where this organization has not performed well. And so I'm looking forward to seeing this. I think this deunification topic should be taken very seriously by this committee and this body. I'm looking forward to getting that report and evaluating it, and then moving on, hopefully to to a little bit brighter future for the profession from there. So,
And I was in error in not acknowledging Ms. Gonzalez's concern. She's absolutely right. There's no defense to not having addressed these matters.
exactly. And again, I agree with her. I think she is right on that, and I think and I think that's not the only area too. So if it was just one area, we could kind of nail that down. But even how that was a long period of time for that to go on without being identified. I'm glad she brought it up today, but I think it's just kind of one small area amongst many others. And so, in any event, I will look forward to.
And you will have more information shortly, as you know, with these various reports, as well as this state auditor report. So you'll have more information to inform you.
Exactly.
But I think these audit reports have been helpful. They've pointed where we do need to focus attention, and we are.
Good. Thank you. Mr. Chu.
Thank you, Mr. Chair. First of all, I want to thank everyone who has been thinking hard about this, as I have. Last year, when we sat in this committee considering last year's bar due renewal bill, I said that I had been very dissatisfied as my experience of a member of the state bar for almost 2 decades, but I was willing to give the bar time to turn the ship around. I might disagree a little bit with the analogy. I'm convinced this year that the state bar is the Titanic. And if we don't turn it around, we will only have ourselves to blame. Let me say a few things to qualify that. First, I've had a number of meetings with the new bar leadership, and I think that you are very well-meaning, and you are bringing very different and important competencies to the leadership that is much needed, but I'm of the perspective that the organization is far too gone at this point. And let me just briefly summarize, because I think we've only touched upon some of the issues that I've been focused on. Let's talk about what we have learned over the past year. First, we got an audit from the state auditor who highlighted discipline issues, the fact that we not only have had an excessive backlog, but to reduce the backlog, there are attorneys that probably should have been disbarred who receive light punishments and are still practicing law. And as you know, just a few months ago, there have been news stories of additional state bar disciplinary failures, the Drexel Bradshaw case in San Francisco, where we have many individuals in my city who've been victimized because of the failure of the state bar to place protection of the public as its highest priority. Second, let's talk about buildings. That same audit pointed out that this bar association spent $77 million on the purchase of a building in LA that this legislature had only approved $10 million for, rather than investing in your attorney discipline system. That was from an audit in June, and then we discover more recently that the same thing happened in San Francisco. And while I don't mind when money is being spent in San Francisco on real estate, After this audit, somehow the State Bar decided, without input or approval from the legislature, to take a $10 million loan on a San Francisco building in the most expensive real estate market in the state. Let's continue what I refer to as Travelgate. We've learned from subsequent public records of all the travel expenses, I suppose, to learn about how bars in other countries are being run, to places critical to the functioning of the California bar in El Salvador, Mexico, Guatemala, Nicaragua, Peru, and Mongolia. And I do think, and I appreciate that that you have chosen to end the expense counts on this, but again, this is only something that we've learned recently, within the past year. And you juxtapose executives traveling to El Salvador and Mexico while we're hearing about hundreds of complaints for the unlawful practice of law sitting in drawers at the State Bar with immigrants who've been victimized by so-called notario fraud artists. And as someone who, in a past life, worked in a civil rights organization to go after these and have not been able to see any conclusion as a state in our prosecution of these individuals, this is very troubling as well. So you add to that last year's Supreme Court decision that holds that the state can only invoke immunity to an antitrust action if the board is actively supervised by state officials, which we're not doing in California. And so, we know that as long as the Board of Trustees is run by the very attorneys it's supposed to regulate, our state could be liable for board actions. I summarize this because I want to explain why my perspective has come to where it is today. So let me just add two other things. It's been pointed out that in the wake of Prop 209, with a prohibition on affirmative action, the bar's ability to advocate for diversity in the profession and access to justice has been significantly hampered. And as the former president of the largest Asian American bar association in the country, this is something that we have just not seen leadership on from the State Bar. As a former public interest attorney, I've heard from hundreds of public interest colleagues who have pointed to the failure of this bar to find funding for legal services to fund the so-called justice gap. So I lay all this out. We've had conversations about it. We could have longer conversations about it. But let me just ask one question in this way. And Mr. Menger referred to those of us who were babies when he was first working on this issue. In 1995, when I graduated from law school 20 years ago, there was a commission that issued a report about the bar and said that the main issues were who should have authority over the legal profession, should California continue to have a unified bar, what changes are needed. 1997, then Governor Pete Wilson said that the bar has become lost, its ultimate message obscured. It is part publisher, part real estate investor, part travel agent, part social critic, commingling its responsibilities and revenues in a way that creates an almost constant appearance of impropriety. I think this begs this suggestion that those who fail to learn from history are doomed to repeat it. We know it has been said by several of your trustees who've documented the long history of cyclical crisis, reform, neglect, and renewed crisis, that every director, nearly every director over the past few decades has been replaced by a new leader, charged to be a new sheriff, a show of effort at change is made, attention of the press and bar turn elsewhere, the bar slides back into mismanagement, failure to protect Californians, and general dysfunction. Do you really feel that you can turn this around?
That's the critical question, I think, Representative Chu, Assemblyman Chu, sorry. I wouldn't have agreed to take this position. I didn't need it. I wasn't seeking it. I'm not a member of the California Bar if I didn't care deeply about the good functioning of a legal system. And I think, in contrast to what you said, what I knew about the State Bar when I agreed to be interviewed was the remarkable work it had done with inclusion and diversity, creating, I think, 16 systems of educating children who might not otherwise think about a career in law. I had a different impression than you did. I was surprised when I arrived to realize that the management dysfunction that I was inheriting, the legacy system I've described, was much deeper than what I imagined. Indeed, our president has asked me, would I have taken the job had I known then what I know now? It's a fair question. Having said that, however, I believe that we can turn it around. I have a remarkable set of teammates. I think in a short period of time, we've demonstrated, if I can build on your metaphor, that we're not just shifting the chairs on the Titanic. We are digging deeply into how the bar is organized and functions. And I do believe that given not infinite time, because you're right, time is passing, we have to get this straightened around, but I think next year we will be in a different position than we are this year, where we are frankly about the business 24/7 of cleaning up problems that, while I've acknowledged we now own them, we didn't originate. So yes, I think there's reason to hope. Now, I'm not taking the position that we ought not to consider changing the structure of the bar. Indeed, you can look at other models, and there's an argument that perhaps it would be a better structure if it were smaller, more focused. But I do think before we do that, before we further unsettle an organization that really is in turmoil as a result of so much change going on now, we need to get through the current transformation and then decide what's the best structure for California.
If I could just conclude, if I had to vote today, if this was what the chair had recommended, I would be very open to supporting de-unification. I think the idea of splitting the bar into a regulatory agency and a trade association following 18 states, which tend to include the generally larger states, with dues payments lower than for the de-unified bar, I think that makes a lot of sense. I think what Mr. Menger has laid out has made sense. And again, this is someone who's paid probably close to about $20,000 of bar dues since I've become a member of this bar. And I will also say that I've considered taking my name off this bill, but I do understand that that would stall reform. And so I do think that the flexibility of what we have at this moment to allow us to publicly deliberate the best way to address challenges is important. But at this point, I've been thinking about this now for a year and a half, and I think we have to act. I think we have to be a bit more decisive than the time frame that's being suggested. I'm concerned that if we continue to wait, we will just continue down the same path of history, and I will be saying to my 7-week-old child, who, when he becomes an attorney, you know, Daddy could have had a chance to fix the bar, but he didn't. And so I look forward to working with you. And again, I want to say I do believe that the current leadership of the bar, you are doing what you can, but at this point, I'm concerned that it's too little, too late.
Thank you. Mr. Chairman, did you want to add something?
Well, this is a complex process. I'm glad we're asking questions of the bar. I'm going to stitch a lot of this together and talk specifically to the committee about what this bill is and where we're going. I'll do that on my close. I'm happy
We've got
to
several
also answer questions, but yeah, I do have something to say on all of this, because I think this is what you're asking and what you're going to be a part of, or I'm going to ask you all to be a part of.
All right, we'll wait for that eagerly in your close. I have a couple more comments. Mr. Alejo, followed by Mr. Gallagher, and then Ms. Garcia.
Thank you very much. I won't repeat everything that both of my colleagues said. I think you're hearing from both sides of the aisle a lot of the concerns that have come out as a result of the State Bar and the transparency that has been provided to the legislature and the public about the ingrained problems within our State Bar. And we have to put it bluntly, and for the public to hear that we're cognizant of their concerns, but the State Bar did put the public at risk by not doing a thorough job in carrying out one of its missions, which is the protection of the legal profession to ensure the highest level of competency. When the State Bar was collecting dues in excess of their expenses and having $32 million in surplus, and instead of focusing on the backlog, purchasing buildings, it certainly, I think, upsets all of us who are part of the legal profession, but certainly the victims who lost out because their complaint or the discipline against that particular attorney wasn't taken seriously by the State Bar. And as my colleague from San Francisco pointed out, many times that they were settled leniently or they were dismissed outright. And so that's very concerning for us. But the other mission of the bar is also equal access to justice. And in this bill and in past efforts and in my meetings with the State Bar, there's been very little effort to look out for the most vulnerable, the poorest residents in our state. As you all know, the IOLTA trust accounts that fund legal aid organizations in California. Those rates have been at an all-time low, haven't increased for numerous years. The Legal Service Corporation, which is our federal funding, has made cuts to our nonprofits, and these are the people who serve those that cannot afford a private attorney. And when the state bar is not addressing those issues, even having conversations with the legislature or advocating how do we properly fund services to the poor in our state, that's concerning too, because there's a silence coming out of an organization who should be advocating for the poorest among us. I'm doing my job this year, trying to push, as a former legal aid attorney, trying to make sure we're providing legal services for the poor. But when the state bar has these other issues, but at the same time are completely silent on an issue that we all know is severe, our poor have nowhere else to go when they're being evicted, when we have problems with the Social Security claim, unemployment insurance, whatever their issue may be. If we're not properly providing funding, especially in light of an economic recovery, and we haven't made any effort either to reinstate the non-mandatory dues or including additional ideas to address this concern in this particular funding bill, it's very troubling to me. And I think I'd like to hear how is the state bar, I know you're dealing with a lot of other issues and trying to clean up a mess that you inherited, but what is the state bar doing to address what we all know is a critical need in funding legal services for our nonprofit legal aid organizations?
Well, actually, Assemblyman Alejo, our president, David Pasternak, has made this a cause this year, and I can't understand how he would have missed you. But he has been in the Capitol talking with both senators and assemblymen on countless times, trying to see if there are not ways to take the Equal Access Fund and increase it. So this has been, what shall we say, something that's been almost an obsession on his part. And I will make sure that he's in touch with you, because I suspect that ideas you might share with him could be helpful.
Well, I've been here 6 years and a member of Judiciary, and I have yet, my 6 years, I'm leaving this year, I've yet to hear the state bar ever advocate for legal services for the poor.
I would just add that this year the State Bar received $44 million from the nationwide class action against the banks, having to do with the loan modification crisis, and that money is going to be allocated by our legal services group of the State Bar, who is currently working with a broad-based coalition of legal service providers primarily to develop the criteria by which those funds will be allocated. So this represents an incredible opportunity for the bar and for our legal services community in California to benefit under the terms of the settlement. Those funds need to be used to advance economic development or to address loan modification issues in particular. But the broad category of economic development does give us, again, a really significant opportunity to increase funding for legal services providers statewide. So that is happening right now.
Ms. Garcia.
I'm not a member of the bar, not an attorney, but I've been on this committee for 4 years. So yeah, so I have been hearing these issues now for a while, but I have very strong opinions about reform and governance structures in general, and making sure that our governing structures fulfill the promise to our public, especially our most vulnerable individuals out there. And when I hear about these immigrants and the lack of support that they need and their files just being stuck in a drawer, it's really disheartening given the values that I have and what I'm here to do in this body. I think given the history and the fact that the bar at times will start to reform itself, we stop paying attention, and we fall down the same pathway. I don't think we're in a place to keep giving opportunities anymore. We have too many vulnerable individuals at risk on a regular basis, and I think we've given enough opportunities. I think that the audit and the transparency that we voted on is giving us an opportunity to really come to terms with the fact that our governing structure doesn't work here, and it needs to be rethought and restructured to make sure that these vulnerable individuals are getting the service they need, and that the bar is fulfilling its promise to the public out there. I don't believe that this organization deserves another opportunity. I have plenty of organizations like this that are not legal organizations, but have been given lots of opportunities. And every time the scandal gets bigger, every time the atrocities against the public get bigger, and every time the opinion of electeds or lawyers gets worse and worse. And so for myself as an individual, I feel that it's time that we turn it around and we start to rebuild that trust. And the only way to do that is by really rethinking the governance structure. Your legacy is going to be one day eliminated. Whatever changes you're making today or you plan to make in the next year, the next person or the next time we're not paying attention, it's going to go away like it's gone constantly. And so sitting here, I don't want to have another year. This is my 4th year on this committee. I don't want to have another year where I see the same problems and it's only getting worse and worse. Or I don't want to come 12 years later and say, oh, there's another audit and we did have improvements, but we went back that same slippery slope and we fall further down. And in the meantime, more and more vulnerable individuals are out there on their own. And so I do hope that as this bill moves, and because it has my names, that we don't wait any further. I would like to see that we have a real governance structure change, and whether it's decoupling or something else, I do think we need to take that seriously, and I do think that this bar is out of time, at least in my eyes.
Thank you. Mr. Gallagher.
Yeah, I mean, for me, we have to execute our oversight function as the legislature, and I don't think we would be doing that in good faith if we didn't really delve into this. And I appreciate that people, that there's new management and people are trying to do new things, but as Assemblyman Chu said, we've seen that before. We've seen that too many times before. If you look back, you know, there's always, okay, this is the new group coming in, we're going to make changes. Maybe things get better for a little bit, but then we're right back to this. So I think, you know, for me, I'm inclined to not support authorizing fees until I can feel comfortable that some real reforms and changes have happened here. And I know it's probably rich coming from us about talking about debt, and from the state of California considering the debt and obligations that we're under, but nonetheless, there's some serious issues there that were uncovered in the audit. And probably the biggest thing is what has been already said is the best thing that the bar does to protect the public is discipline lawyers who are acting in bad faith, who are unethical. And I think the audit clearly showed that has not been the case. And even more concerning, the favoritism that has been shown, the clear favoritism that has been shown to some lawyers over others. And that's a very big problem for me. So until I can feel really comfortable that some real substantive changes have happened here, and I would agree, I think we need to really look at whether or not we should deunify the bar. I'm not saying I'm an advocate of that today, but I certainly would really like to look at what that would look like, and considering all that's happened over the course of years here. So for me, I'm going to be voting no today, because I don't think I can in good conscience say that we can authorize these fees and then continue this without real substantive changes being made at the bar.
Mr. Chu. Mr. Chowder. Apologies.
My colleagues have touched upon the possibility of reform or decoupling concept, which I'm basically open for suggestions, but I want to focus in on a couple of specific questions. First question, it's my understanding that future bar dues were at one point used as collateral to secure a building loan. And despite efforts to roll that back or reverse that transaction, certain bar fees are still obligated to use to pay for that loan. Is that not correct? Or how does that restructuring work?
No. So this is the issue of substituting a debt service reserve fund for a revenue pledge, and that has been completely reversed. So we have now a debt service reserve fund in place.
So none of the membership dues will be used as collateral? None will. What was the structure being used in that rollback?
Well, I just want to clarify the structure. So when the bar purchased the LA building, That loan was secured by two types of collateral, a debt service reserve fund and the Howard Street building as collateral for the LA loan. The Howard Street loan, and I want to clarify what that $10 million was for, there's 3 floors of vacant space at our building on Howard Street, the most prime commercial real estate market perhaps in the country, that's been sitting vacant for quite some time. That is space that in order to rent out and to generate revenue from, we need to get it up to a certain standard of occupancy. So that is what the loan for Howard Street was for. The bank originally wanted to secure that loan with another debt service reserve fund. A debt service reserve fund requires you to put money in the bank for the life of the loan that you cannot touch, and is traditionally not an optimal form of collateral because you then cannot use those funds to advance any other goals of your organization. So in lieu of a debt service reserve fund, we went forward with a revenue pledge structure. After getting the feedback that we got, we reversed that transaction. So now both the LA building and the San Francisco building are secured by 2 forms of collateral, a debt service reserve fund and a pledge on the Howard Street building itself. But that debt service reserve is comprised of our general fund monies. So I just want to be clear when we're saying there is no membership fees going to support the building. It is being secured by our general fund dollars, which do include membership fees.
The original idea of using membership due as a collateral, was that the result of the executive director, or was it the result of decision made by the board as a whole?
Well, the board didn't approve the structure, but certainly, I mean, I take responsibility for that idea. I was trying to advance, again, really prudent principles of fiscal management of an organization. If you look back at last year's fee bill, there's a specific requirement that in moving to implement workforce planning recommendations, the bar looks at all of its revenue sources, including its fund balances. So tying up significant amounts of fund balance in a debt service reserve fund does not make much sense when you need to be able to access those dollars to implement legislative priorities. So that was the motivation. I do take responsibility for it. We moved it and advanced it to the Board of Trustees, again, with no intention to tie the legislature's hands on reducing dues.
Got it. Second question, of the 300+ complaints filed that went unprocessed, how many of them have been serviced or paid attention to as since the time you found out about these 300 complaints?
Right.
What's the status of the investigation on those complaints?
Well, let's see. Several steps have been taken. First, they were reviewed in a triage process to see which ones were meritorious and should move forward. There was then outreach to the LA County District Attorney as well as the City Attorney, and I believe also the State Attorney General. And there are now meetings with 2 members of our Regulation and Discipline Committee, the RAD Committee, along with staff from the Office of Chief Trial Counsel, with the LA County Attorney. And I believe also meetings with the City Attorney, and they're separating out which jurisdiction should consider handling the various complaints, keeping in mind that there are 2 avenues. One that the bar itself manages is really a civil remedy, but it's a limited impact remedy. And so what we're trying to do is simultaneously offer law enforcement authority the opportunity to consider before the year statute runs whether they have something in one of these that ought to be prosecuted, even as we continue simultaneously to investigate. And I believe after this review, what are our numbers? I think they're about 170. They're well beneath the number of 300. I think it's somewhere in, I'm sorry, I can't be precise, but it's about 120.
Is it correct that most of those 300 complaints deal with UPLs, unlawful practice of law, and immigration related to most of them?
A small part. Very small part, actually.
Thank you.
Ms. Chow. Ms. Garcia, you had a brief follow-up?
Yes, to follow up on Mr. Chu's statement and Chow's statement earlier about these loans, the San Francisco building. And you talked about fiscal management and being responsible fiscal agents. But if we look at the analysis, you took a $10 million loan, and a year prior, you guys adopted rules about what you were going to do when we're going to have expenses of $2 million or more. It looks like you didn't even follow your own rules that you put in there to make sure you were being responsible fiscal management and providing the board with all the information they needed, alternatives. You didn't provide them with risk about this $10 million loan. And so even if you're implementing these changes to be more fiscally prudent and you're not following them, how are we supposed to believe that you are okay to continue with the current governing structure that you have? Can you respond to that?
So I disagree with that characterization. The cost-benefit analysis, extensive cost-benefit analysis was conducted. The loan is anticipated to be paid off in 5 years, a little over 5 years. And once rented, the space will generate between $2.5 and $2.9 million in new revenue annually. So I think that the math on that is quite simple in terms of the financial viability and value of the loan, and that information was presented to the board. Some of that happened before I arrived, and some of it happened after I arrived. So again, while I take responsibility for the issue on the pledge of revenue, overall, does that loan make sense? Absolutely. What doesn't make sense is to have 3 vacant floors of space in San Francisco at the Embarcadero of commercial real estate, and that was the situation that we had in place.
But presenting the potential benefits or revenue stream does not really present all the risk. As a mathematician and as a person who has real estate investments, there's no guarantees. And is this the most cost-effective in both short-term and long-term? Was that analysis provided? Were alternatives provided to the board so that they could make a more because it's your personal opinion doesn't mean that they're making a fully informed decision of all the risks and all the benefits.
So before we arrived at the bar, the board had made a decision to take out a loan to renovate that space. And certainly when Elizabeth and I came on board, the then president of the board was very clear with us about the priority to execute this loan for the tenant improvement space. So again, that decision about whether or not a loan should be taken out to renovate the space happened before we arrived. What we arrived to was a term sheet from the lender that was not favorable to the bar or thereby to the public or to the dues-paying members. The term sheet had a very severe prepayment penalty, a 10-year term that didn't allow us to prepay without a very significant penalty. We worked to modify that, and in addition, it had the debt service reserve structure. So the decision about whether or not to enter into a loan to renovate the space had happened before we arrived, and that was a clear mandate that we received from the president of the board upon coming into the positions.
Mr. Ting.
Well, I've never felt so good to not be a lawyer today. I just want to clarify my vote. I'm going to support the bill today, but I am 100% in support of what my colleagues have been saying in terms of the reforms that have been needed, and I'll be reserving my right to vote against it if we don't see those changes really adopted into the bill coming on the floor. It's been clear that these issues have been ongoing, as Ms. Garcia has mentioned, and I think that it's time to really, frankly, face the music and make sure that those changes are adopted. It's, I've been in the legislature. It's rare that we have this amount of vociferous opinion from so many attorneys who are unified. I think it's almost impossible to bring so many attorneys together in a unified voice, so congratulations on that. But I think, unfortunately, it also means that the situation has gotten so dire that there really needs to be fairly drastic and immediate action. And I think if I don't see that immediate action, I can't support this bill on the assembly floor. But I will help you get it out of committee so you can go back to the bar and make those changes. But those changes have to be immediately made.
Thank you, Mr. Tang. Additional questions or comments from the panel? All right, let me weigh in. I have a question, two questions, one from Ms. Parker and one from Mr. Mangers, which I will get to, but let me put them in context. I would like to associate myself with virtually everything Mr. Chu said to kick off this debate and that most of my colleagues have said here. I'm going to vote for this bill, realizing that uppermost in my mind is the picture of Lucy pulling the football out from Charlie Brown again, which is an old reference that goes back to when Mr. Mangers was young. Nevertheless, I'm going to vote for the bill. I think you've heard the objections very clearly. But Mr. Chu is right. We heard those last year, and we were told last year isn't the time to bring them up because the vehicle originated in the Senate, and don't worry, next year we can deal with these problems because the vehicle will originate in the Assembly. We're now dealing with that vehicle, and we still have the same problems. I hear about new bar leadership. We're always hearing about new bar leadership. You've said that before, but the new bar leadership is frankly troubling to me. Within the first week of Mr. Pasternak being elected bar president, I had sent him an email congratulating him, offering to work with him, raising some of these issues, and I got back from him a very nice email saying, yes, he looks forward to working with us. I have never met the man. You said he's been up here walking the halls. Well, maybe he's visiting just Democrats, but Mr. Alejo has never met him either. I've never met you, Ms. Parker. And I find that troubling that new bar leadership is saying, oh, trust us, trust us, trust us, but you haven't sat down in our offices to give us some more detail. I have met on this front, and she's walking up, Ms. Wada, who does a fantastic job for you folks. Fantastic. She's actually the reason I'm going to be voting for this bill today. But there are, to my mind, some disassociations with this new bar leadership and this legislature that is supposed to provide oversight. So with that in mind, my first question. Would you like to answer some of these charges, Ms. Wada? Because I have used your name, but certainly not in vain.
No, I appreciate that, and I won't, I would like to respond to a lot of the comments made here today. I do think that some of them are not entirely accurate, but I wanted to clarify for the record that we have, with every committee member on this in this committee, have attempted to meet with all of them multiple times, including Mr. Alejo, and at points were unavailable. So I just want to make that clear. That conversation has been attempted many times.
All right. So my question. You held up a chart, Ms. Parker, and said when you came in, you were tempted to treat this like a business and look at the business aspects of things and focus on, and I think your phrase was our principal business. I am curious, in your mind, what is the principal business of the bar that you should be focusing on?
And I think that's an obvious answer, so thank you for an easy question. It's public protection, period. First stop, I mean, there's just nothing else. The problem where it becomes, I think, a little difficult is how do you protect the public? One thing is very obvious, and that is we discipline attorneys. But we do a number of other things, too, that feed into this mission, as I think everyone will agree, Mr. Mangers as well. And so the question is, do we say that public protection does not involve, for example, our Judicial Nominations and Evaluation Committee? Does it involve or not our Client Security Fund? Does it involve or not our Lawyer Assistance Program? And, I could go on, and you begin to say, or I began to say to myself, this is more complex than what earlier I understood. Yes, discipline does stand out as a terribly important function, but there are other things as well, and to Mr. Gallagher I would say, one ongoing concern is how do we prevent particularly small and solo firms from getting caught up in the disciplinary web? We know that they sometimes don't have the systems and the education that they need to avoid these problems. This has been studied. When I point to that, I start talking now about a proactive public protection mission to stop some of these problems before they occur. And so it was in this process, Assemblyman Wagner, that I found myself beginning to say, it's a harder problem than what initially I understood. There are also a middle set of activities, and here Assemblyman Chu mentioned these, where we talk about access to justice, where we talk about legal services. These contribute, I think, to the well-being of our legal system. And at the end of the day, isn't that what the legal system ought to be doing? It is about public protection. And that's why in my opening remarks, I expressed a real concern. Our legal system will not work for us if 85% of our population cannot access lawyers, no matter whether they're diverse, where they come from. This is a reality today. And so public protection, I think, really does then become more integral to what we want our California legal system to be. And that's why I began to think, you know, I was being a little bit glib initially. I do have to stop and think harder. Now, the sections are perhaps the most obvious example that could be equated with a trade association, and some people do, but I think you also heard the section say, we're about educating our members. We want competent members, but we're also educating the public, and we're also serving you when you decide what kind of legal systems, what kind of laws you should be passing. So all of this is not to say that I have an answer. It's to say that I'm beginning to understand that there are more questions than I realized.
And my question, and that's a great follow-up, is to Mr. Manders, does not your proposal for deunification in large measure, to my mind at least, get us to the point where it sounds like Ms. Parker wants us to be? We're focusing on the principal business, and maybe we can define it broadly or narrowly, but that's for the legislature to do. Doesn't that solve, in your mind, some of the problems that have been raised here?
Mr. Chairman, after 5.5 years serving on this body, I absolutely agree that that is the course of action we must take. This organization is badly distracted from its regulatory functions because of the time it spends on its trade association functions. And I admire Elizabeth as highly as one can, but it is not as complex as being characterized here. The California Medical Association has sections. It has counterparts that mirror every aspect of the bar, and yet it has found over the years that it's quite capable of separating those functions into a liberated trade association that is at liberty to operate without Bagley-Keene, without paying excessive overhead to the state bar. It could form a PAC. It could become a powerful force on behalf of the attorneys in California, except that it's inextricably interrelated with its regulatory functions, and thus it has to bear all of those public burdens that normally it would not. So when we say access to justice, Jenny, all of these things could easily be placed over on the regulatory side because, of course, they're related to public protection. And all of the trade association functions could be separated into their trade association, just as New York, Pennsylvania, Ohio, Illinois, New Jersey, big states comparative, have already done this and are operating just fine. In Nebraska, the Supreme Court ordered the bar to deunify itself in 30 days. Now, Nebraska is not California, I'll warrant it. And it will take longer. That's why our proposal, for which there is already language in committee that we've proposed, our proposal would give the bar an entire year to work through those things collaboratively with the chief because of the unique relationship the bar has with the chief and with the Senate side. So it's being portrayed as deeply complex, regrettably, because this competent leadership here inherited chaos. But out of chaos, there should come not just fixes, as Assemblymember Chu suggested. This is a moment for reform, significant reform. And if it can happen in New York and the other major big states that have done it, it can happen here.
Thank you. Additional questions or comments? All right, having exhausted the subject, Mr. Chairman, good luck. You may close. Sum it all up.
Let me tell you why I'm looking for everyone to vote yes on this bill. A yes vote is a vote for reform. We started reform last year. The legislature put in place the Public Records Act requirements and the Bagley-Keene requirements. What we've learned from the Public Records Act request is we've been getting information now out of what's happening at the bar that has fed into a lot of the dysfunction and the things that we actually need to reform. We absolutely need to do reform, and that's what we have to move forward with. We need to continue that reform that we started last year. Right now, I am agnostic on unification, deunification. It's become a very volatile issue. and I get your perspective. This is a rare moment where all 10 of the committee members are weighing in on the State Bar. That shows how significant that is, and I want you to stay engaged. If we move this bill, which I want to move this bill, and I think you should all be a part of moving this bill, we will continue this reform effort. There have to be significant changes made to how the bar is governed. And whether that's unification, deunification, we will sort of get there. But we need the information to know how we're moving forward. That information is going to come out of the audit, which is coming out in just a couple weeks. We're a little bit before that. That's going to drive potentially substantial changes to this bill. The governance task force was ordered by this legislature a number of years ago. They were supposed to report to the legislature in 2014. The then executive director decided it was not important, and that task force never came up with its report. We're now 2 years past that due date. It's supposed to come out in July, we're told. I hope we get it, because it will be informative to what we need to do. But if we don't get it, we still have to move forward with all of the pieces that we do in fact have. This question is up to us and Senate Judiciary and the Chief Justice. We're going to be the decision makers in reforming the State Bar and addressing all of these issues. And yeah, there were concerns about the 300 complaints that were dropped in a drawer. That is not excusable. The way that the future fees were encumbered, actually because of this is all in the analysis of the 1957 statute, said that if that was the case, then the state legislature could not reduce the bar fees. That is entirely unacceptable. This bill takes action and removes that provision so that this legislature and future legislatures will not be hampered. Not only was it bad practice, but it's a way of trying to take away from the legislature its due authority to oversee and to provide regulations. In the middle of all this, there are trustees, at least one trustee, who is out in the public saying the legislature has and should have no role in oversight of the bar. So there's a tremendous credibility problem that the bar has, which is why the decision around bar governance is us, Senate Judiciary, and the Chief Justice. And I've been meeting with the Senate, I've met with the Chief Justice. We're going to be continuing to put together a plan to offer to you to be able to move this forward. Senate Judiciary and this committee will hold hearings on exactly this question of governance, and we can thoroughly vet out. We just had a real taste of the debate around unification, but around bar governance and about reforming what the bar means to the people of California, not just the lawyers, but to all the people of California. We will hold informational hearings about that to thoroughly vet it so that you have in front of you all the information that you need. Now, Mr. Ting left, unfortunately. We are not going to have a complete picture in this bill, I will tell you, by the time it gets to the floor. It's going to go through appropriations. We will do amendments as much as we possibly can. But I have committed to the chair of the Senate Judiciary Committee, and I've committed to the Chief Justice that we will not be making amendments without involving them in that process so they know exactly what we're looking to do. We will then be doing amendments probably on the floor as it moves over to the Senate, and again, you will be involved in that. It's not going to be that it goes over to the Senate and you're blind, because it will be coming back for concurrence. And if we don't get substantial, if we have not addressed all of those issues, I mean, we have the one organization that should not be in violation of antitrust, potentially very much so, because it is regulated, is managed by market participants. We would not stand for that in any other context. So if we have not addressed those, then we're not going to fix all of that this year. But I want to give you a plan enough that you have confidence in to be able to move this forward. If we cannot do that, by the time this comes back around next summer for concurrence, I will ask you to vote no on that bill. Because if we need to create crisis, we will. But I want to make sure that we have thoughtfully, deliberatively, and in a coordinated way managed the next steps of reform. First steps we should all be very proud of. We put the Public Records Act and we put Bagley-Keene in play. We have been learning from that. The public's been learning from that. A lot of the press is now starting to get information that we had asked for, I had asked for, and we didn't get as complete a picture on it. Just the fact of the encumbrance of this building, this $10 million loan on bar fees, We were told nobody knew that decision was made without that information. As we look at the record that was created, there was information. There were internal memos that said, yeah, I think they knew what they were doing. So it was putting something in place without advising the legislature in a way to tie our hands. And if that was done completely unknowingly, without the information that was present and giving it to the Board of Trustees, there's a structural problem within the bar. And if it was, then that was patently dishonest with respect to the relationship with the legislature. And that is why I'm telling you, the decision around bar governance and reform that we are embarked on is this committee, Senate Judiciary, and the Chief Justice. So that's why I'm asking you, the yes vote on this bill is moving forward our ability to drive that reform. And that's why I'm going to ask all of you. And Mr. Gallagher, I understand your frustration, but I'm going to ask you to be with us, with this committee, because if we can't be together with this very, very clear message that's been articulated today on what we expect as the Assembly Judiciary Committee, our role, our obligation of oversight of the governance of a very, very important body to the public of the state of California. And again, we're not going to tie our own hands about what those decisions are going to be. I have a great sense now of where everyone is. I'm not surprised, but I appreciate that everyone has been willing to articulate those, because that gives us that much more ability to really push for reforms that I think are absolutely necessary. That's what I'm asking you to move today. It is incomplete. We don't have a lot of answers to those questions, but we're going to start to get the data, the facts, the information we're going to need to be able to do reform. That's what I'm asking of you today. Join with me, join with Senate Judiciary. Let's work this. Let's do something we can all be very proud of, and do it on our terms, on our time, and in a way that we can have the best effect for all of our constituents across California. Thank you.
Mr. Chairman, I will entertain a motion. Moved by Assemblymember Chu. Is there a second? Second by Assemblymember Alejo. Call the roll.
Stone?
Aye.
Stone, aye. Wagner?
Aye.
Wagner, aye. Alejo? Alejo, aye. Chow? Chow, aye. Chu?
Aye for reform.
Chu, aye for reform. Gallagher?
With the chairman's commitment that we're going to insist on these reforms, I will vote yes today.
Gallagher for commitment. Garcia? Holden? Garcia, aye. Holden? Mainshine? Mainshine, aye. Ting?
The bill is out. Thank you, sir.
Thank you, Mr. Vice Chair. Okay. Ms. Grove was next on our list. I know.
Mr. Gatto said he's going to be less than 5 minutes.
Okay. With your agreement. With your agreement. All right. That moves us then to item number 5, AB 2748. Mr. Gatto.
Thank you. First of all, I want to thank the committee for their amendment.